Hi, this is New York bankruptcy attorney Jay Fleischman, and today's question is whether your spouse needs to file for bankruptcy if you file for bankruptcy. In New York, which is not a community property state, you can only be held liable for any debt that you have signed for. In other words, that you have become legally obligated for. If you signed up for a credit card and your spouse did not sign up for that credit card as well, and I'm not talking about a spouse that has just gotten a second copy of your card as an authorized user, but is rather a signatory to the loan. If you have gotten the credit card and your spouse is not a signatory to that credit card as well, then your spouse cannot be held legally liable. Therefore, if you are over your head in debt and you need to file for bankruptcy to relieve yourself of your debt obligations, and your spouse is not under the responsibility for paying any of those debts, then your spouse need not file for bankruptcy with you. If, however, you are in a community property state, you need to speak with your attorney, because in certain cases, the spouse may be held legally liable. New York State, where I practice bankruptcy law, is not a community property state, and therefore spouses cannot be held legally liable merely because you are married to one another. You marry one another for love, not necessarily for one another's debts. For more information and to get a copy of my free special report about consumer bankruptcy, you can visit my website at www.newyorkbankruptcyhelp.com. This is Jay Fleischman, New York bankruptcy lawyer, and I'll see you next time.